Administration is an insolvency procedure whereby a company which is struggling financially is given a breathing space under the protection of a statutory moratorium. And what the moratorium does is it prevents suppliers and other people who are owed money from taking legal proceedings against the company or its assets unless permission is obtained either from the court or from the appointed administrators. And the purpose of administration is to enable a business which is struggling financially to be rescued or reorganised without receiving creditor pressure via legal proceedings or other forms of creditor action, or to achieve a better outcome for creditors than would be the case if the company were to be placed into liquidation. Firstly, you should ask the contact at the company to give you the name and contact details of the administrators, which you can pass on to your collections or your credit control team. If you're unable to get that information in that way, then you can search online using either Companies House or the Gazette, but it can take up to 7 days for that information to appear. You could speak to other creditors and suppliers of the company, but sometimes the details of the proposed administration will be kept under wraps. That's because once knowledge leaks out into the marketplace that a company may be struggling and going into administration, creditors might pile in and seek to take their own immediate steps to protect their position. Also, the market value of the company could be adversely impacted by news of the impending administration leaking out. Once you've got details of the administrators, you should contact them to provide details of the claim that you've got against the company, which is called your proof of debt. And if you're a supplier of goods for which payment hasn't been made, you should ask to be provided with a retention of title or reservation of title questionnaire for you to complete, because you might be able to recover your goods for that process. For larger cases, for example, large retail administrations, the administrators would probably set up an online portal for creditors to register their details and receive information about the case in that way. What action you take will very much depend on whether you're a relatively small trade supplier or whether you're perhaps key to any successful turnaround or restructuring and rescue of the business. Your supply of goods or services to the company will probably be governed by your terms and conditions, your T's and C's, which are your contract with the company. And what rights they give you will obviously depend on their individual wording. And they may provide that the contract is terminable on an insolvency event like an administration, or automatically terminated by reason of the customer going into insolvency, into administration. That's how things have stood up until now. But in response to the COVID-19 crisis, the government has introduced a bill, the Corporate Insolvency and Governance Bill. It's going to bring about some important changes to the law in this area. It's likely to come into force in early June. And one of the measures the bill is going to bring in is a prohibition on the rights of a supplier to terminate a contract or do any other thing, for example, amend your payment terms as a result of a company's insolvency. So what this really means in practice is that you're going to need to continue to supply for goods or services to an insolvent company, even where you're owed a lot of money. But there will, of course, be a requirement on the administrators, if they're trading the business, to pay you for those goods or services.